Hello, students. A very warm welcome to all. Today, we shall discuss about the introduction to company and the types of companies. So, we shall begin our discussion on the fascinating subjects of our company laws. So, it is a part of corporate accounting, and company law basically governs the formation, the management, the functioning, and the dissolution of companies. In modern business, company play a crucial role in economic development. So, employment generation and capital formation plays a significant role in the context of company law and companies. In the learning outcome today, at first we understand the meaning, nature, and the essential characteristic of a company under company law. Next, we easily differentiate between the various forms of business organizations such as sole proprietorship, partnerships, LLPs, OPC, the one-person company, private company, and the public companies. Explain the basic principles and the corporate law, including the legal personality, limited liability, and the separation of ownerships and managements, and then analyze the important company laws concepts such as the shares, share capitals, and the shareholders, directors, memorandum of associations, article of associations, and classify and evaluate the different types of companies on the basis of incorporation, liability, control, and the transferability of the shares. So, basically, this is our the forms of business organizations. In this lecture, we will understand the basic principles and the importance terms associated with the companies such as shares, shareholders, and the directors, and the constitutional documents. So, come to the forms of business organizations. So, before understanding the companies, we must compare the different forms of business organizations. A sole proprietorship is owned and managed by a single person with unlimited liability. A limited liability partnership or LLP provides the limited liability protection while maintaining the flexibility. A one-person company combines the benefit of sole ownership in the corporate structure. That means the board of directors are there present, separate legal entity with a required nominee, and considerable paperwork in the application to ROC to be made. In public and private companies, are the separate legal entity managed by the board of directors, where the ownership is divided among the shareholders, and the major companies is limited liability, and the most important thing, that is perpetual successions. So in the private and public companies basically differ the number of shareholders and the power of ownership. Now come to the 5 principles of corporate law. So these are the 5 fundamental principles of our company laws. The first is legal personality. So what is legal personality? Legal personality means a company has a separate legal identity, and this identity distinct from its owners. Second is limited liability. The shareholders are liable only up to the unpaid value of the shares. So it is a very encouraging principles of a company. The third is transferable shares. So here the ownership can be transferred easily. The fourth one, shared the ownership. So the separation of ownership and management means the shareholder owns the companies. The shareholder owns the companies, but the directors manage the company. And the finally, separation of ownership and management means the ownership is distributed among the multiple stakeholders. Now come with the basic terminologies of the concept of companies. The first one is company, then share capital, then shareholder, then director, and then memorandum of associations and the articles of associations. So before moving further, let us understand and try to clear the concept of above mentioned terms clearly. So the company means a company is an artificial legal person that is created by law. Law means the Companies Act 2013. Before 2013, the Companies Act was introduced in 1956, and today we all follow the Act of 2013 and the amendment, the later on, that is the 2017, 14, 19 and so on. And the share means a share represents a unit of ownership in the company. A share represents a unit of ownership in the company. Share capital refers to the total value of shares issued. That means, suppose the authorized capital of a company is 1 lakh and company fixed the share value, the face value of the shares is 100. So the number of shares equal to the authorized value divided by the face value of each shares, that is 1 lakh divided by 100, that is the number of shares comes out 1000. Next, the shareholder. A shareholder is a person who owns the share in the company, and in the company's structure the shareholder is the owner of the company. Shareholders have the voting rights of the company. Then the directors. The directors means who manage the affairs of the companies. And the memorandum and articles is very important to every company. The memorandum and the articles of associations are the constitutional documents governing the company. So these two articles are very important. Now come to the term of company, the concept of company. The term company doesn't have a strict legal meaning, but under the section 2 subsection 20 of Companies Act, a company means a company incorporated under the act or any previous company law. A company limited by shares means the liability of members is limited to the unpaid amount on their shares. And in simple terms, the company is a group of persons. A company is a group of persons who come together for a common business purpose and creates a separate legal entity to earn the profit. So the main motive of a profit seeking company is to earn profit, but the company always maintains some rules and regulations, because a moment the company is registered and it is clothed with a legal personality, and thus the company comes into the existence. So the company is a legal personality, so anyone can sue against the company, and then the company will liable for the case, not the owner, because in the context of the company, the owner and the company have separate legal identity. Now comes to the meaning of shares. Shares means Shares means a share represent a unit of the ownership in a company. Shares usually have a face value and may be used as to prove the ownership of the company. Shares usually have a face value and may be issued at a premium or a discount. Premium means when a share issue more than its face value, then we called the share issued at premium, and when share issued at a lesser value than the face value, then we called the share issued is at a discount. For example, if a company issues 10 shares having 10 each at a premium of rupees 22, that means the total face value of the shares 10 into 10, that rupees 100, but the total value of shares is 10 into 10 plus 22, that comes 32. So when a company issued the shares at a premium of 22 rupees, then the company collect 32 rupees for each shares, and for 10 shares 320 rupees. Now the question is that, is a share tangible or intangible property? So basically shares is considered as intangible movable property, and the ownership is evidenced through a share certificate. So share certificate is the ownership of a shareholder having the shares of a company. Now come to the share capital. Share capital means the aggregate face value of all shares issued by the company. It is expressed both in the monetary terms and the number of shares. For example, the share capital of the company is rupees 1 crore, consists of 10 lakh shares of face value 10 each. So here, so the total share capital becomes 10 million. So it is the authorized share capital that register of companies allow to collect the money from the common public by issuing the shares. Now types of the share capital. So in the types of the share capital, there are some steps. The first step is the authorized capital. Authorized capital means that amount of portion is permitted by the register of the company. Under authorized share capital, the amount of capital which is issued by the company to collect the capital from the common public, that is the issued capital. Out of the issued capital, the public is willing to pay and collect the shares, that is subscribed capital. Under the subscribed capital, up to the amount of money that the shareholder paid to the company, that is paid up capital. So the first authorized capital, then issued capital, then subscribed capital, then called up capital, then paid up capital. So these are the types of share capital. Now, authorized share capital means the maximum. Authorized share capital means the maximum capital that the company is permitted to raise. Issued and allotted means it refers to the portion that offers to the investors. Paid up is capital is the amount that actually received by the company from the shareholder. For example, if authorized capital is rupees 1000 consisting of 100 shares, but only 40 shares are issued and fully paid up, then the paid up capital becomes 40 into 10 rupees. That means 400 is the paid up capital. Now, shareholders and the members. The term shareholders is generally used the interchangeably with the members. So shareholders is nothing but a member of the company, and a subscriber to the memorandum automatically becomes a member upon the incorporation. Any person agreeing in written to become a member and whose name is entered in the register also becomes a member. Similarly, as per the law, beneficial owners recorded with a depository are treated as member. Thus, the ownerships and the memberships are closely connected. The concept in the company law. So this is the particular definitions and the concepts of the term shareholders. Suppose it's a diagrammatic presentation. Shareholder A 30 shares, shareholders A 30 shares, shareholding A is rupees 300, and the shareholder B 10 shares holding the rupees 100. So the total issued and the paid up capital of the company 300 plus 100, that is 400. This is the examples of shareholders. Now, the another important thing in this picture, shareholder A holding 30 shares and shareholder B holding 10 shares. So this demonstrates the proportional ownership of the company. Generally, greater shareholding, that means the shareholder A provides the greater voting rights, greater voting powers, and the greater participation in the profits. So shareholder A having the more profitable portions rather than shareholder B. Now come to the directors and the management. So this is most important things of a company, that is the shareholders appoint the directors to manage the company. The board of directors makes the strategic and the operational decisions. The company earns profit through business operations, and the directors are expected to use their powers in the best interest of shareholders. And this reflects basically the principles of the separation between the ownerships and the management. So basically the shareholders selects the directors by using their voting rights in annual general meetings. So shareholders, the board of directors, then the companies. Now it is our alternative view that the connected contracts theory between the shareholders, directors, vendors, consumers and the companies, because company has to have to satisfy all the parties, that is the shareholders who wants a huge amount of dividend, the directors wants this good remuneration, consumers wants in good product in low price, and the vendor wants the clearance of payment time to time. So basically it is a contracts theory. Traditionally a company is viewed as an entity that is controlled by the shareholders through the directors. However, the connected contracts theory suggests that a company is a network of relationship involving the shareholders, the directors, the employees, the consumers and the vendors. Therefore, the modern corporate governance increasingly considers the stakeholder interest beyond only the shareholders. So this is the conflict. Now comes to the memorandum and the articles of associations. The memorandum of associations defines the memorandum of association defines the company's relationship with the outside world. That means it contains the essential details such as name, objectives and the liabilities of the company. But in the other hand, the articles of associations regulates the internal management and the relationship among the shareholders, directors and the employees. So together these two documents from the constitutional framework of the company. But memorandum of association is generally tough to alter, but the articles of the association may alter, may change through a special resolution by depending the situations of facing the company. So to conclude this part, we discuss the foundations of company with the company law, forms of business organizations, principles of corporate laws and the key concept such as shares, shareholders, directors and the constitutional documents. So these concepts from the base for the understanding the advanced corporate legal structures and the governance mechanism. In our second part, we basically discussed the elements of companies, types of companies and the advanced part of companies. Now we focused on the important portion, that is the various types and the classification of the companies. So in the context of the classification, basically the companies can be classified on different bases, such as on the basis of incorporation, on the basis of liability, on the basis of control, on the basis of transferability of the shares and the geographical operations. Classification helps us identify the legal structure and the functioning on the different business entities. So, on the basis of incorporation, there are three types: Royal Chartered Company, Statutory Company, Registered Company. On the basis of the liability, there are three types: limited by shares, limited by guarantee, unlimited company. On the basis of the control, holding company and subsidiary company. On the basis of transferability of the shares, private company, public company. Then domestic and the foreign company, one man company or family company, or companies not for the profit. Now come one by one. Classifications of the company on the basis of the incorporations. So, number one, chartered company. So, chartered company means these companies are formed through a royal charter granted by the king or queen. So, their powers and the privilege are defined in the charter itself. So, these companies are not governed by the Companies Act. Historically, the examples include the East India Company, Bank of England, Hudson Bay Company. Such companies cannot be started in India, and such companies can't be established in India today, and these are the chartered companies of the nations. Next, come to the statutory company. So, what is the statutory company? The statutory company means these companies established through a special act, passed by the parliament or a state legislature. So, their constitutions is governed by the memorandum and the articles of the associations, while their audit is conducted by the Comptroller and the Auditor General of India. So, examples include Life Insurance Corporation of India LICI, Reserve Bank of India, State Bank of India, and Oil and Natural Gas Corporation ONGC. These are the statutory companies of India. IDBI, Railway, Electricity, and statutory company enjoys the autonomous status, and it need not use the word limited next to its name. So, these are the power of a statutory company. Now, come to the registered or incorporate companies. So, registered or incorporate company means these companies are those incorporate under the Companies Act, and the incorporation means legally creating a separate business entity recognized by the law. Here, the process includes the preparation of documents, compliance with the legal requirements, and the registrations with the register of the companies. Most of the companies whose operating today falls under this category. Next, once it is done, all the requirement is done, then the company is submitted to the ROC of our nations. However, there is a slight difference between the registered or incorporate companies. So, next, the second classification, that is the classifications of companies on the basis of liability. So, first thing, the company is limited by the shares. So, in a company that is limited by the shares means the liability of the shareholder is restricted to the unpaid amount on their shares, and if the shares are fully paid, the shareholders are not personally liable for the company's debt. So, this form protects the personal assets of the shareholders, and it is the most common type of the company structure in our nation. A shareholder can't be called upon to pay more than the amount remaining the unpaid of the shares. So, the shareholder's asset can't be called upon for the payment of the liabilities of the company if nothing remains to be paid on the shares purchased by him. Such the companies known as the share company, and this company is limited by the shares. Now, the second class of under this classification on the basis of the liability, that is the company is limited by the guarantee. Here, a company limited by the guarantee is one having the liability of its members and limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the asset of the company in the event of its being wound up. So, basically a company limited by the guarantee limits the liability of the members to the amount and they agree to the contribute there during wind up, and these companies generally do not have the share capitals. They are commonly formed for the charitable purpose, for the educational purpose, for the cultural purpose, or the non-profit seeking purpose. Next, on the basis of liability, the third thing, the unlimited company. So, it is an unlimited company, the members have the unlimited liability. If the company's assets are insufficient during the liquidation, the members may be personally responsible for the outstanding liabilities. Although the legally permitted, this form is rarely used because of this is an example of highly financial risk. So, this type of company is very rare. Next, on the basis of the control. So, on the basis of the control, there are two types. One is holding company and another one is subsidiary company. So, in holding company is one that controls the another company known as subsidiary company. So, control may exist when the holding company controls the board of the directors of the subsidiary company, or the holding company holds more than half of the equity share capital of the subsidiary company, or the holding company controls another subsidiary company indirectly. So, holding company are the important in corporate groups and the business expansions. Next, come to the subsidiary company. So subsidiary company is owned or controlled by the another company that called the holding company of that subsidiary company. If the parent company owns more than 50% of voting rights, if the parent company controls the operation, if it owns the 100% shares, it becomes a wholly owned subsidiary. But this structure is widely used in the multinational corporations, multinational companies. So, it is a holding company or the parent company, and its operations are controlled by the holding company. So, holding company and the subsidiary company is a complementary of each other. Next, come to the private company, private limited company. So, on the basis of the transferability of shares, there are two types of company. One is private limited company and another one is public limited company. So, a private limited company is owned privately by the individuals or the groups, and its important features are the restrictions on transfer of shares, limited liabilities, shares can't be traded publicly in the share markets, and this type of company is popular among the startups and the families. And on the name of this type of companies to the next is the end of the company's name, pvt.ltd. If a company stands ABC Private Limited, ABC company pvt.ltd. So that means it's a private limited company. In the case of public limited company, the PVT word is missing, only limited company. So if the company shows ABC Limited, so that means it is a public limited company. A public limited company can issue the shares to the public through initial public offer or IPO in the primary market, and after issuing the shares first time, its shares are traded on stock exchange. Such companies require the greater legal compliance and the transparency. A public company must obtain a trading certificate before commencing the business operations. So that's why the Reliance Digital company, Tata Motors company, ITC company, these all are the public limited company. Now, classifications on the companies and the transferability of shares, that is the difference between public limited company and private limited company. So the first difference is the minimum members. In the public limited company, the minimum member is 7. The private limited company, the minimum member is 2. Maximum members, the maximum members for public limited is unlimited, but on the private limited is 200. Minimum directors, in the public limited the director number is 3, the private limited is 2. Minimum capital 5 lakh. The minimum capital for private limited 1 lakh. Invitation to the public, it is eligible for public limited because the public limited collects their capital through IPO. In the context of private limited, these options is not available. Issue of prospectus, yes, in public limited company, but in private limited company the collections of the share capital is restricted. So now questions of prospectus. The quorum at annual general meeting, the 5 members is strictly for public limited and 2 members is strictly for private limited. Certificate of commencement of business, that is mandatory for public limited, but that is not mandatory for private limited. The term used at the end of the name, for the public limited only limited, and the for private limited PVT Ltd. The managerial remuneration, there is no restrictions on the public limited companies, but for the private limited companies can't exceed more than 11% of the net profits. And statutory meeting is mandate for public limited companies, but statutory meeting is not mandate for a private limited companies. Now we all come to the 1% company, that is OPC. So what is OPC? OPC is similar to the sole proprietorship. 1% company by OPC allows a single person to enjoy the benefits of the corporate structures. So unlike the sole proprietorship, the liability is limited. So therefore, the personal assets of the owner remain protected even during the losses or liquidations. So this is the one and only advantage of a OPC company with compared with the sole proprietorship. Next come to the other types, that is the domestic company. A domestic company is a company that registered and operating within the national territory under the Indian laws. So any company that is not classified as a foreign company is treated as a domestic company. Next come to the foreign companies. So a foreign company means a company which is incorporated in a country outside the India under the law of that country. After the establishment of the business in India, the following documents must be filled with the register of the companies within the 30 days from the date of establishment. Number 1, a certified copy of the charter or the statutes under which the company is incorporated, or the memorandum and the articles of the company translated into English, the full address of the registered office of the company, a list of the directors and the secretary of the company, the name and the address of the person of the resident of India who is authorized to accept on behalf of the company service of legal process by any notice served in the company, and the full address of the company's principal place of the business in India. So a foreign company is incorporated outside the India, but they establish the business operations in India. Such companies must submit all the above mentioned documents within the 30 days of establishment. Next, come to the multinational companies. A multinational company operates multiple countries. So these companies conduct the production, the marketing and the research activities. The marketing, the production and the research activities internationally to maximize the global profits. So example must include with the Microsoft company, Coca-Cola, Nestle, Sony, Pepsi, Apple. So these are the multinational companies. Now come to the most important, that is Section 8 companies. Section 8 companies earlier known as the Section 25 companies in the legal form of non-profit organization or non-governmental organization, registered under the Section 8 of the Companies Act 2013 and has its objective of the promotions of the arts, science and commerce, education, sports, research, religion, social welfare, charity or other similar objects. So basically income earned by the company is applied only for the promoting the objects of the company and it can't be distributed to the promoters. It shall enjoy all the privilege of the limited company subject to the obligations. There should be the minimum 2 shareholders, there should be the minimum 2 directors, at least one of the directors should be the resident in India, and no requirement of the minimum capital is there. It can't be formed with or without share capital. So the Section 8 companies is formed for charitable purpose, a non-profit objective. The profit earned are used only for the promoting companies. Objectives can't be distributed among the members. And these are the features and important features include These all are the minimum requirement. So, to conclude, the companies can be classified in various ways. Depending upon the incorporation, the liability, the ownerships, and the operational structure, understanding this classification helps us to analyze the legal position, the risk, the ownership pattern, and the management structure of different companies. And these concepts from the foundation for the advanced study in the company's concept and the corporate governance. So, thank you so much for patient hearing. Thank you.